let me first start, as I should, by thanking the organizers for having this gathering. It looks like it's going to be a fantastic day for all of you, and I feel very privileged to have been invited to have this conversation with you today. And I hope it will be a conversation. I will be back for questions, and I hope that you and I will be able to have some good conversation. I know that, doing things electronically isn't optimal, but necessary. In this way, we get to reach obviously a lot more people. So that's the upside. So as you heard, my name is Allison Nichol. I run the Legal Defense Fund at the Epilepsy Foundation of America, a lifelong disability rights, civil rights lawyer. I'm going to talk today. I want us to be in conversation about a few things today. I have selected the topics for today based on the number of calls that I get. Most of my days are spent in conversation with people who have legal problems, trying to find them either solutions or attorneys to help them, including a lot of you, I think, that are here today. We've had these conversations. So I picked sort of the top 3 topics that I hear about that are creating the most difficulty for people with epilepsy. And those are the ones I'm going to talk about are employment. Employment discrimination is rampant against people with epilepsy. Education, I know that people have lots of questions. I get lots of calls, especially about K through 12 education and what are known as Section 504 plans and individualized education plans. So we're going to talk about that a little. The third may be a little more foreign to you, and that is adverse interaction between a person with epilepsy and law enforcement. So I always like to at least touch on that, because I think it's something that people don't think a lot about, and yet, many days it rivals employment for the #1 spot of the calls that I get where people really need help immediately. There certainly are, the Americans with Disabilities Act is a very broad civil rights law. It protects people with epilepsy. Epilepsy is a disability within the meaning of that law, and as well as the Rehab Act. And so you really have, I call it cradle to grave coverage under the ADA in virtually every aspect of your life from discrimination. And that includes all public accommodations. But we have limited time, so I wanted to focus on kind of the top 3 subjects. I'm going to start with employment. I think there are 3 very important points to make about employment, and that they all revolve around the ways in which the Americans with Disabilities Act, which applies to state and local government employees, private employers of private businesses, employees of private businesses, as long as there are 15 or more employees. The Rehabilitation Act basically is the same coverage, and that's if you are a federal employee or the person you're dealing with is a federal employee. But it's the same rules, it's just called something else. So I think the most important things for people to know about employment is you do not have to disclose your epilepsy in order to get hired. In fact, the ADA has a very strong prohibition against any forced disclosure during the interview process, on a job application. You can't be asked if you have a medical condition. You cannot be asked if you take medication. You can't be asked how much sick time you took in your last job, because that might indicate or lead to a conversation about whether or not you're a person with a disability. So there are just very strict prohibitions in place because, before the ADA, you would be asked that and you would disclose that you had a disability, in this case, epilepsy, and then you just wouldn't be hired. But it would be very difficult to prove that that was the reason that you weren't hired, because that would have been one of all kinds of questions you were asked. So the employer could have easily said, oh, I didn't like her personality. We wanted somebody who fit in the family more, whatever. And so we had to take that ability away from employers and make it clear that if you're asked that in violation of the ADA and then you don't hire someone, that really raises suspicion that that is the reason. So you do not have to disclose until you have been made an offer. You know, if there's been an offer and an acceptance. In some jobs, you're required to take a medical examination. This is most common now for firefighters, EMTs, police officers, public safety jobs, and a few others, people who are heavy equipment operators, that might happen. And so once you have an offer and acceptance, if you go into that next phase and they give you a medical examination, which they have to do for everybody that they're hiring into that, they can't just pick you out and say, I think maybe this person has a medical condition. I'm going to send them for a medical examination, but not everyone I'm hiring into that job. And they then, in that, they can then, of course, give you a medical examination. It will likely come up that you are a person with epilepsy. And then what happens? Well, what happens is they're not allowed, just because they now have that information, to withdraw that job offer solely because you're a person with epilepsy. They would have to prove that the fact that you are a person with epilepsy, and I mean by that an individualized assessment of your particular, how epilepsy, affects you individually. So not this general, nobody with epilepsy can work here. It would have to be something specific. So in other words, if you're a person who only has nocturnal seizures and you're never going to be working at night, it should be completely irrelevant to you. So they can't pull the job offer just because you have epilepsy. They would have to demonstrate that either you'd be a direct threat in the job as a result of that, or it would be an undue hardship in some other way for them. Once you become an employee, they really cannot inquire about whether or not you are a person with epilepsy, or frankly any other disability. People with epilepsy come, in many different forms, and you may have many people may have additional medical conditions to that. So it's really, I'm talking about epilepsy because that's kind of our focus, but this would be true generally of any kind of medical condition. So once you're employed, they can really only come to you and ask you questions about whether or not, kind of question your health. If one, it appears as though you're doing your job unsafely, and they have some right to inquire about why that is, or if your production dramatically falls off. So they shouldn't really start in that case with the presumption that it's health related. But if there's some indicator, that it's health related, then they may be able to ask some questions. But again, they're not going to be able to take any action on that basis alone, right? They're going to have to make an individualized determination about your individual epilepsy that you somehow are not going to be able to safely perform, and that's a pretty high standard under the ADA, or that it's somehow you're unable to continue to do the major functions of that job. So those are the rules. It's not my position to tell people whether or not they should disclose during the interviewing process and hiring process, only that they don't have to. Many people come to me and are very concerned about not disclosing. They're sure if they don't disclose the first time they have a seizure at work, they're going to be terminated, or the employer is going to look upon them as if they weren't completely honest, or most importantly, there will be no one in the workplace who will be able to recognize their seizure and know what to do about it. Whether or not you choose to disclose in that process is up to you. There is another way of dealing with that concern that I recommend to people. That's kind of the next thing I want to talk about with respect to employment, and that is the need for what's called a reasonable accommodation. What I say to people who are concerned about not disclosing up front is that if your concern is based on having a seizure at work and having no one there kind of know what they're supposed to be doing for you, I tell people to put that through the reasonable accommodation process. So the reasonable accommodation process is for individuals with disabilities who need some kind of an adjustment to the manner in which the job is done, or something like that. So in this situation, this very specific situation about making sure somebody at work knows how to deal with the fact that you might have a seizure, I would go through the reasonable accommodation process. I would do something akin to sort of a seizure safe plan that kids do in high school and elementary school. You know, I'm disclosing to you, this is what I have, this is what needs to happen, this is what a seizure looks like for me, this is what would need to happen if I had a seizure in the workplace. And that's going to vary widely, right? Some people are going to need immediate attention and want an ambulance called. Other people aren't, and most people don't. Most people I talk to, they want a quiet place to slowly recover, and then they want to go immediately back to work. The reason I recommend you go through the reasonable accommodation process is A, you're more likely to get the job if you don't disclose during the interview process, and B, the reasonable accommodation process is completely confidential. So you're going to ask for that reasonable accommodation. They'll ask for some kind of medical documentation. Be very careful with medical documentation. Never give over all your medical records to your employer just because they ask for them. All you need to demonstrate is proof that you have epilepsy and what that looks like for you. And that, you know, a note from your doctor should be sufficient for those purposes. And then that information should only go to HR. It should be kept in a separate set of files. Right, should not be contained in your ongoing personnel file. So if you're applying for down the road for some promotion, that person shouldn't be able to open your personnel file and say, oh, this person has epilepsy, I don't want them working for me. So it's a separate set of files. Only certain people in the workplace are going to need to know this information. Your immediate supervisor is likely to be one of them, and then someone in HR. And again, the rest of it really depends. You know, if you're working on a road crew on a highway, that's a much different scenario than if you're working from home or you're working in, you know, an office. So how you accomplish accommodations can vary, but that is how, you know, that's how I would recommend people handle that. I just want to say, we have further resources on this. Epilepsy Foundation has a YouTube channel. We've done 4 or 5 videos on employment. That's how important it is. All of the stuff I just said is in those videos. It also tells you how to get a remedy if you've already been terminated. Many people that come to me have already been terminated. And then you have to start the process with the EEOC. You know, all of that is laid out in these videos as well. So please feel free to access our video channel. I think a lot of this information will be helpful to you and the people you're trying to help. So that, in a very small nutshell, is employment. That is the highlights. I want to talk now about education. And yes, I do also get questions about higher education at times, but the great bulk of the questions, of course, that we get about education are K through 12. There are really 2 paths for accommodating kids in K through 12 who have epilepsy. And again, I'm focusing on their epilepsy, but it easily could be that a child with epilepsy is a wheelchair user, is blind, is deaf or hard of hearing, has learning differences, needs extra time on tests, may have ADD or ADHD, or, you know, other conditions that lead to difficulty with learning and a need for some accommodations in school. So the 2 paths really are Section 504 of the Rehabilitation Act, which allows or mandates, I should say, what are called Section 504 plans. So for instance, if you're the child that you're dealing with only needs somebody on the bus, let's say, in case they have a seizure or something very, in other words, something unrelated to the act of learning, right? That's a Section 504 plan. If, in fact, the child is having difficulty with the learning experience, which is really pretty broad, then you're under the IDEA, which is a different federal law from 504. And when we're over here in IDEA, that means that the child's learning is impacted in some way, and we're going to build a plan around that. One of the primary differences is that in 504, you don't really have a lot of due process rights, but in IDEA, the parents have a lot more due process rights in formulating the plan, in making sure the plan is right, and asking for changes to the plan in the future. Not every kid holds steady for, K through 12. They can change over time, and the IEP should be reflecting that. So I have a tendency to push people into an IEP situation, if at all possible, because I think the requirements for what the schools have to do is greater under IDEA than it is under 504. The upside is there's always an upside and a downside. The upside is you get more due process rights. The downside is whenever you have a lot of due process administrative rights, you have to exhaust that process or finish out that administrative process before you can go to federal court if what the school is doing is not what they should be doing. So I will give you just one example, and this is a case that's before the Supreme Court this term. And it's sort of hard, the facts are sort of hard for even me to believe after 30 years of doing this, but there was a young man who was deaf and had requested in his IEP a sign language interpreter. Seems like the simplest thing in the world to me. The school persistently refused to provide this young man a sign language interpreter. They finally, he went through all of high school without a sign language interpreter. And as a result of that, didn't learn anything, unsurprisingly. And so is now having to go back through high school all over again at the deaf school near where he lives with a sign language interpreter. But that didn't happen until they were sued. They went through the IDEA process. That was a settlement. You cannot get damages, however, under the IDEA. So although the school agreed to pay for the sign language interpreter and the further education, this young man is now 4 years behind his peers, 4 years behind in learning and 4 years behind in eligibility for college and for employment. So this is a case in front of the Supreme Court for some, legally reasons I won't go into. But that is one example of where having an IEP may have worked against him because they had to exhaust all those administrative remedies. And, it took all the time that he was going through high school to accomplish that before they could go on to federal court and say, can we put a stop to this now? So those are the primary differences. As a general matter, I think IEPs work very well. Schools tend to, and let me explain. So 504 is administered by the federal government, but the IDEA is so there's federal money that goes to the states, and the states agree to do certain things to provide a free, appropriate public education under the IDEA. So it's administered really by the state and the local school districts with federal money. Over here, if you have a complaint of a 50, that they're not doing what they should under your 504 plan, that complaint goes to the United States Department of Education's Office of Civil Rights, right? Because there is no administrative process for that. Over here, there's a more lengthy piece by piece state administrative process. Those are important, I think, distinctions for folks to know. It isn't necessary to have a lawyer for either process. It's helpful to have an advocate, especially if you are a parent who is completely unfamiliar with these systems. So those are the basic differences. 2 seconds on college. I will say that once you get to college, all of that falls away, right? I get calls a lot from parents who are very surprised to learn that in college, they don't have these options. And it really, the responsibility really falls wholly to their child, who is now viewed as an adult, and they need to, make sure they get what they need in the college setting. They have to go to the reasonable accommodation coordinator for the university or the college they're in. And the rules are not as generous when you get to that point. And so I really strongly encourage both students and parents, when they're looking at the college experience, to get on the listservs, to go to the websites, to have open conversations with the folks at the colleges that your child is looking at, and find out if they're disability friendly or not, because some really are not, and there's really no way to change that culture. And so I think you want to be pretty circumspect and careful about, rolling that into your decision making. So that's the kind of the best advice I can give you on that. So that's really, and again, we go on our YouTube channel. A lot of the information that I just gave to you is available. A new video that we just put out this year. It just outlines exactly what I just said. It also tells you how to file a complaint under Section 504 and how to access the administrative process under the IDEA. I want to now just, I will touch briefly on one other thing, which is driving. I think you know that there are limitations on driving, not just because you have epilepsy, but because you've had a seizure related event, right? Not necessarily where you're driving sort of at all. In some way on epilepsy.com, there is a database of driving laws in every state, very easy to access. We do update it periodically. I know there were major changes, for instance, to the New York law about 18 to 24 months ago. That is reflected now in our database. What you need to know as a person with epilepsy: do you have a duty to report? Does your doctor have a duty to report? The length of time is usually from either 3 months on the low end to a year on the high end. So that information is all available. I don't want to spend any more time on that, but I just wanted you to know the information is there and available for you on an ongoing basis. Okay, thanks. And I want to close out by telling you something you don't know. I get calls all the time from people who've had an adverse interaction with a law enforcement officer because they've had a seizure in a public place or they've had a car accident as a result of a seizure. Law enforcement arrives. They assume the person is either overusing drugs or alcohol or being non-responsive to their orders. Usually, if the person's in a post-ictal state, people can put their hands on each other. My guy usually ends up in jail with charge of assault on a police officer. If you do not think that this can happen to your children or the young adults or the adults in your life, you are incorrect. It happens all the time. We are working on a training right now for law enforcement officers and lawyers and judges and everyone in the law enforcement community to tell them that what you're seeing may be a seizure and none of the things you think that it is. So I think that's a good, we're running on time here. It's a lot of information, but we will have an opportunity to be in further conversation about this. And I wanted to thank you all for coming, to thank each of you for all that you do every day to improve the lives of people with epilepsy. And with that, I think it's a good time for me to close out, and I'll see you a little bit later.